Welcome, everybody. My name is David Greenwald. I am the founder and director of the Vanguard, and we are honored to have an esteemed panel today to discuss a very important matter, AB 1542. The bill sets up a pilot program in Yolo County, which is next to Sacramento, for those not familiar. However, it has attracted much broader, I'm being told to change. There we go. It has attracted much broader attention with the belief that it could expand beyond Yolo County once it's expanded. So the bill authorizes judges to sentence people to confinement in a treatment facility instead of a prison or jail if the judge determines that their crime was motivated in part by substance abuse. What proponents argue is that substance abuse abusers need medical treatment rather than prison or punishment. And many reformers support increasing the availability of evidence-based voluntary treatment for people who struggle with substance abuse. Opponents, however, argue that the bill is basically a way to force people involuntarily into a secured facility or a locked treatment regulated by the courts, and they are concerned that this blurs the line between medical care and punishment. As the Human Rights Watch put it, it runs directly counter to the principle of free and informed consent to medical health treatment, which is a cornerstone of the right to health. Conflating health treatment and jailing as envisioned by AB 1542, it risks human rights abuses and is ineffective as treatment and takes resources and policy focus away from initiatives that are more likely to help people. So joining us today, as I said, an esteemed panel. So one of the panelists, Kate Chatfield, unfortunately could not make it today. However, we have Assembly Member Kevin McCarty, who is the author of this bill. We have Professor Leo Beletsky, who is a professor of law and health services at Northeastern University. We have Kellen Rusinello from the Drug Policy Alliance. We have Robert Canning, who is a Vanguard board member, but also a retired psychologist at CDCR. And we have Rod Beatty, who is an attorney in Yolo County on the Conflict Council. I'm going to turn this over really briefly to my colleague on the Vanguard board, Liz Kim, who's going to do a brief announcement, and then we will introduce Assembly Member Kevin McCarty.
Hello there. I don't know if I'm not supposed to be on the screen, but in any case, I'm excited to be here to hear all of you esteemed panelists on this very important topic. But I did want to remind our audience, the viewers, that next Thursday is the Big Day of Giving, the annual Big Day of Giving, where you have the opportunity to contribute to social justice organizations, especially like Vanguard, who will be having two great speakers, change makers, Los Angeles District Attorney George Gascon and Alameda County Public Defender Brendan Woods on the issues of policing and race in America. So we really hope that you can join us on next Thursday's virtual event at 7 p.m. We'll be distributing flyers with the link, as well as putting it in the chats here if you're interested, and a reminder to please attend and share that event. Thank you.
Thanks, Liz. I wanted to start our discussion with the Assembly member who's sponsoring the legislation. And Assembly Member McCarty, could you kind of describe your bill? I gave it a cursory overview. And then also, we understand that there were some significant amendments this week, and so maybe you can explain some of those as well.
Yeah, and by the way, do we have Christina Salazar? She's my ledge director. And
Yes, I'm here,
Right
Kevin.
here.
she's here. Can we get her? I can't see you, but I'll guess you're just like Elizabeth. No, no, no foot, no visuals. That's no
We're
fair.
behind the scenes.
Sorry. I will turn on my camera in a little bit.
Yeah, and I wanted to say hi to Elizabeth too. So I guess that's the first thing I want to say is that this is an important bill. I 100% believe in it. And if it was all that the opponents say that it is, I wouldn't be authoring it because I've been with many of you in the trenches fighting on police reform, authored groundbreaking legislation to make sure the police don't police the police. I authored the bill last year to bring back voting rights for formerly incarcerated. I wrote the law to change the parole process for people and reintegration credits, and have been co-author and championing plenty of bills to lessen mass incarceration in our state. And so I am kind of at a loss to the extreme pushback for this, because I think it's a really reasonable policy, and we'll talk about the amendments, and I'm listening to the opposition all along. You know, just where the bill is today, it passed the Assembly Public Safety Committee with unanimous support about 2 weeks ago. I got 7-0 vote. It passed the Health Committee a couple of days ago on I think it was like a 14-3 vote, something like that. And ironically, the 3 people that didn't vote for it, they were Republicans, because they think that nobody should have any chance for treatment. They want people to be locked up all the time. So that's kind of what we saw from the right. But essentially, I from a long time, know that we have, besides the criminal justice, mass incarceration, addiction in our society, we have very poor systems when it comes to people in the criminal justice system, and homelessness and addiction, and just they're intertwined, unfortunately. And we used to have more robust drug courts, and for wrong or right reasons, we decriminalize a lot of low-level events that no longer focus on incarceration. And so there isn't many times the desire, the push to entice people to go and get treatment. And so a few years ago, I decided I wanted to do a bill to kind of help bring back the notion of kind of drug diversion type programs. And I went and toured the YOLO facility for juvenile justice about 2 years ago, and there was 4 kids there, as you know, and it's built for 150, and we're doing different stuff with juvenile halls anyway across our state. And I thought, wow, wouldn't it be nice to use this for something more productive, like drug treatment? Of course, get rid of the bars and the guns and everything at the facility. So the DA of YOLO came to me and says, hey, I have an idea. Why don't we do a pilot project here in YOLO, where when individuals who are arrested and then sentenced for felonies that have a documented and proven correlation to drug abuse and drug addiction, and they have substance abuse disorders, could be an option for the individual at sentencing to choose this over incarceration. And if they choose this, they would also have the chance to have their record expunged. And I thought, wow, that's an innovative idea. So I'd like to author that. So I'm authoring the bill. I categorically, I have a great amount of respect for you, David, but I think you're absolutely wrong in your characterization of this, that it has a judge sentence somebody to these facilities. An individual is sentenced to prison or jail, and we have an attorney on here, a defense attorney, Rod Beatty, who can go into greater detail on the logistics of the criminal justice system, because I'm not a lawyer by any means. But the intent of the bill is, if somebody is about to go to prison or to jail for a sentence, a felony sentence, they would have a choice. Do they want to instead go to a secure treatment facility in lieu of their sentence? And so I know some of the supporters say that we're focusing on incarceration, but the reality is here, these individuals, they're not going home. They're not even going to be able to go to their living room and have an ankle brace for a 6 months probation term. These are individuals that otherwise would be in a state prison or a longer term county jail sentence. And so this would be a pilot project for 3 or 4 years in Yolo County to try it out. And I think, you know, why you're seeing a 100% progressive champ like me authoring it, and unanimous support and the public safety and so much support, is because the status quo just isn't working. We're hearing from our communities that it's not quite working. And so there's going to be pushes to change the conservatorship laws and issues like this, because we need to think outside the box. So the amendments that we took this week are in direct response to some people with concerns. They want to make sure that the program as developed is science-based, and I always forget the acronym, but the bill, Christina, can you remind me like what specifically that
The ASAM?
Yeah.
Yeah, and I can jump in and
Go
just
ahead, Christina.
yeah,
You jump
I'll
ahead. Once you, yeah.
summarize the amendments. So so the latest amendments taken in Health Committee were really to make sure that everything was evidence-based. And so at the point of somebody's assessment, they're going to assess them for psychologically to make sure that they're ready for treatment, and everything that the program is going to offer is with the guidelines of the American Society of Addiction Medicine. So the treatment, the assessment, we also clarified for the outpatient portion of the bill that once somebody is ready to leave, that they're going to have a plan for counseling, housing, all that good stuff, to have a holistic approach for when they're done with the treatment facility portion of it. And also it clarified that we are going to use money from the opioid settlement funds. And I believe the last amendment is in terms of, and I think this is the question that was sent to the chat. So if I understand the question correctly, they're asking about the timing of the program. And so I just want to highlight that the assessment is going to be done by treatment professionals. And so if they were to be sentenced to, let's say, 2 years in prison, but the assessment says that they would benefit from a year in treatment, you know, it'll be based on whatever the treatment providers say. I don't know if that answers the question, if that makes sense, but everything is going to be based on the recommendations of the treatment providers. And also, if the person has a successful, let's say they were originally set to be sent for the treatment providers for a year, but they're doing so great in the program and they should be done by 9 months, right? Because they're going to be constantly assessed, then they can be released sooner than that, if that makes sense for folks.
And then lastly, there was one other piece, and I'm sure this is going to come up. This is probably the most put forward opposition argument, is the issue of voluntary and coerced. And we listened to the opposition, and at first how DA Reisick wanted to do this, it was going to be mandatory, and then we before we even introduced the bill, we had talked about that. So it's voluntary, and some would say it's still not voluntary. I get that. I truly believe it is, but we do have you know, I kind of like say a cooling off period. I kind of attested it's very different when you go buy a car. You have 72 hours to say no afterwards. And so once somebody chooses this option upon arrival at the facility, and after a couple of days, if the individual or the leadership facility think it's not an appropriate fit, the individual could back out. So they could say, you know what, this isn't right for me. I don't want to be here. But keep in mind, they're not going home. They're not going to even go home with an ankle bracelet and 6-month home arrest. They're going to go to a state prison or a significant term sentence in a county jail. So that's where we're at today. And we'll stop here, and I look forward to other people's questions, comments, and I'm here to engage with all of you. So I'm perfectly fine answering any questions or just listening to feedback.
All right, thank you. So I wanted to bring in Professor Beletsky and Kellen and get kind of a understanding of the research on voluntary versus involuntary placements, and also kind of an understanding of any concerns you may have about this specific legislation. So I don't know who wants to jump in, but go for it.
Helen, do you want to go first or?
Feel free, Leo. Go ahead.
Okay. Thanks, David, so much for inviting me to comment on this. Even though my main academic appointment is at Northeastern University in Boston, I also have an appointment at UC San Diego. So I have a foothold in California. So this is somewhat closer to home than it might appear at first glance. The first thing I wanted to mention, if I may, is the importance of using precise language when we talk about these issues. So I applaud the general intent to make non-criminal sort of interventions to address substance use, but the word abuse is something that I think bears a little bit of consideration, because abuse is a term of art in criminal law. And we talk about abuse when we talk about child abuse, spousal abuse, and so forth. And the term drug abuse, even though it's still very much mainstream parlance, is in way cutting cross purposes with efforts to decriminalize and deploy non-criminal responses to substance use. So we can talk about problematic substance use, we can talk about misuse, but the term abuse itself is well, it's technically even like, what does it mean to abuse a substance? But it does invoke criminal law interventions. And, you know, this is not kind of a personal attack on anyone. It's just a consideration that I wanted to bring up. The second thing that I wanted to mention is that the effort to scale up involuntary commitment of folks with addiction and substance use problems is a national trend. So currently there are 38 states. I posted in the comments a link to a webpage from my lab that lists all of the states that have involuntary commitment for substance use. It's been increasing in the response to the overdose crisis. And in many cases, it has sort of rebranded and repurposed criminal legal approaches to substance use under the banner of treatment. In my other home state of Massachusetts, there are actual prison facilities that function as, that have been repurposed as quote unquote treatment facilities, and they offer services that are very similar to what is offered to to folks who are convicted of criminal crime, of criminal behavior. And so I think that maybe Assemblymember McCarty, the pushback that you're seeing is actually a response to what is a national trend of, you know, again, the repurpose and rebranding of criminal legal approaches to being called treatment, but not being a treatment. In fact, I think that this bill is different in some respects. And so, you know, maybe that just placing that in that national context is helps explain the pushback, because there's, you know, this movement afoot and there's opposition to that. I think that from a, you know, I have kind of I've bridged the fence between public health and law and trying to translate empirical evidence into policy spaces. And I think that it's worth mentioning that the evidence around involuntary commitment or involuntary treatment or coerced treatment is mixed at best. So we know, for example, that you know, folks, when they re-enter the community from involuntarily being committed involuntarily for treatment, they're at extremely high risk of overdose, in the same way that they're at risk of overdose after a period of incarceration. We know that internal motivation is really critical for success of drug treatment. And so if you're sort of, as was referred to, using kind of external incentives or coercing people into treatment, the outcomes are not as effective as people seek treatment voluntarily. And we also know that many facilities that are created for the purpose of inpatient treatment that is involuntary have really pervasive problems that are similar to prisons and jails. So sexual assault, sexual abuse in this context, abuse is warranted. Suicide, lots of other issues that are, I mean, COVID is an example. So whenever you're putting people into institutional settings, you're creating a platform for problems to arise. Now, in the context of the specific bill, you know, the kind of the differential is a little bit less defined because you're facing a choice, at least as you're describing it, Assemblymember McCarthy. If the choice is between going into a criminal legal facility versus a secure facility for treatment that has Medi-Cal coverage, as the bill was amended, perhaps, you know, there's one kind of a lesser of two evils. And that certainly bears consideration, but the question arises, why not emphasize treatment that is, you know, proven the most effective, which is in many cases outpatient treatment and keeping folks in their community, focusing on wraparound services that may not be available in a confined setting, and you know, focusing on health and supportive services as an alternative. Now, you know, we could say, well, that's just not an option. You're really creating a more sort of progressive option out of the two, and I'm sympathetic to that rationale. But then, you know, would ask, you know, why are we not thinking about more off-ramps into places that are not confined, secure settings, but settings where people can thrive? So I will just end there and turn it over to Kellen.
Thanks, Leo. Yeah, I would just emphasize what Leo said here on the evidence of coerced and involuntary treatment, that at best it is mixed and at worst it creates harms for those who are actually being forced into the treatment. The meta-analyses that have come out on coerced treatment almost all say that due to the lack of a finding of its effectiveness and the potential harms, that we should be prioritizing non-coerced treatment methods. And so, like Leo was saying, we should be focusing on getting people into the treatment that's right for them, which for most people is going to be treatment in the community. And, you know, going to the ASAM criteria being built into this bill, if the only option is a secured residential facility, then the ASAM criteria is really kind of meaningless. One, because ASAM criteria doesn't include secured residential as a level of care. And also because if somebody gets assessed according to that criteria and it's determined that the appropriate level of services is actually outpatient, that's not an option for them under this program. So it seems a little bit at this point like lip service saying that it's going to be health professionals making these decisions, when really the only option is an incarceration setting, which is more than likely than not going to take over all of the health services provisions and be more like a prison than it is a treatment setting.
Sorry, couldn't unmute myself for a second. I wanted to bring Rod into the discussion. So from a defense attorney, how does this legislation impact the approach that you'll take?
I have been a lawyer in Yolo County for 40 years. I've done almost exclusively criminal defense since I was honored to join a conflict defense panel in 1990. I think for too long for me to even think about it, the vast majority of my clients have serious substance abuse problems. Alcohol is certainly predominant, but drug use and the opioid crisis and the methamphetamine disaster has put so many of my clients in very dangerous situations. I'm fascinated by the argument that Assemblyman McCarty makes in regard to the bill itself. And I want to stress that as I read the statute and as I made a even firmer commitment to support it, most of my clients go through the criminal justice system if they're not serious or violent felonies, and at some point are offered residential or outpatient drug treatment without incarceration. So as I read the bill and as I read what I'm hearing, this is sort of a last resort for many people. It does not prevent me from running the kind of motions that I need to run in criminal defense, suppression motions, misconduct motions, motions to dismiss and the like. This is something that occurs when my client is either convicted or by his plea or by a jury trial, which means he gives up none of his rights to litigate the system. And then when he stands before the judge and the judge says, really, there's just nothing left for you except a residential treatment facility that is somewhat locked down, or you're going to go to prison or jail. I think that that's a very reasonable thing for a judge to say. I'm fully supportive of this program. I'm once again proud to be a resident of the city of Davis and the county of Yolo. It just seems to me that whenever progressive ideas are considered and hopefully adopted, that our county and our city are at the forefront of it. And I want to also commend my opposition, because I've been opposing district attorneys for 40 years, but I know of no other district attorney's office more committed to keeping people out of jail or prison. I don't know of the district attorney's office or a county that's more focused on rehabilitation efforts and attempting to give people the help that they need. So from a criminal defense standpoint, for myself, I am fully supportive of this and look forward to what we all know to be true, which is the devil is always in the details. So I think we need to know where this facility is going to be. I think we need to know how it's going to get paid for. I think we need to know what kind of professionals they're going to be there. I want my clients' families to have full access to their incarcerated loved one. And I want the facility, as many residential facilities that are not locked down do, to have a plan to assimilate my clients back into the community, because eventually they will face the same temptations on the street that every one of us face every day. So my short answer is I'm very honored to have been chosen to be a member of this panel, and I'm fully supportive of Assemblyman McCarty's bill.
And Robert, in your experience, do we have the programs already in place to be able to do some of the things that this bill is trying to do?
Thanks, David, and thanks for allowing me to be on the panel with these good folks. I think I'm going to echo what Karen Larson, who's the director of our Health and Human Services Agency, has said to the Board of Supervisors, and also Tracy Olson, is that we do have a lot of options before people get sentenced, before they're convicted and sentenced. And this is one of my main points of contention, is that we're not using the resources we already have in place. So for instance, this population is essentially an 1170, what's called an 1170 age population. And these folks typically are they're in the jail already. Why aren't we offering these services in the jail while they're waiting for adjudication and sentencing? We have no programs right now in the jail. We have some treatment space that's coming online soon. And I think that we should be taking these funds and using them to create the programs earlier in the process. And also, we are moving in Yolo County into what's called a crisis now model of interventions, so that interventions for substance use disorders and other kinds of psychosocial problems, such as mental health problems, wouldn't be funneled into the criminal justice system. As many of you know, the county has passed a resolution supporting the Stepping Up initiative, which is a national initiative of county governments to prevent people with mental health problems from getting into the criminal justice system. Now, and the reason this is important is that at least 50 to 75% of those who suffer from substance abuse disorders also have co-occurring mental disorders. And so any treatment program at any level and at any point in the criminal justice spectrum should be taking that into account. And so I think that although there are some individuals, and I think the district attorney has identified somewhere around 200 individuals, although nobody's seen that data to know exactly who they are, would qualify for this program. My hunch is that those people you could intervene with those people earlier in the process. The county's embarked on a very intensive program to study how to intervene earlier to keep people out of the criminal justice system. So I think that if we could sort of transform this bill into a bill that provided funding and services earlier in the process, I think we'd be doing better. I also have concerns, although I'm not a fiscal maven about this sort of stuff. I know that there's money in here for treatment from Medi-Cal or the opiate litigation, but there's a lot more that goes into this. We're talking about evaluating this program 1 and 3 years after the person leaves. They've got to have assessments before, and so I'm concerned about who's going to pay for this, how this is going to be funded. And of course, that has, I think, yet to be worked out. But those are my main concerns. And also, one final thing, I think I want to echo what Kellen said. I'm not sure that ASAM has in their level of care levels mandated or coerced treatment, and that's a concern for me. It's nice to have the ASAM language in there, but if it's in a coerced treatment setting, then it really doesn't conform to their guidelines. Thanks,
If
David.
I could just jump in for a second on the Medi-Cal question. It's very unlikely that Medi-Cal will be able to pay for these services. Medi-Cal includes an exclusion for people who are considered inmates of a public institution, and being forced to stay, restricting somebody's freedom by making them stay in a institution will almost certainly categorize them as an inmate. So Medi-Cal is likely not an option to pay for this service.
Yeah, I just want to jump in, and I know I can respond. I'm trying to keep notes here, but that last issue is irrelevant because it's not in the bill anymore. It specifically states that it would only be other county resources, including the opioid settlement or whatever the county board of supervisors deem that they want to focus on.
Right. It's relevant in the fact that we're now using other resources that could be used for voluntary treatment.
Yeah, so that's up to the county board of supervisors. They are a democratically elected body, and they voted to endorse this, and they'll have to make that choice. This wouldn't happen if this bill passed. It would authorize them to create this effort. So
go ahead, Leo.
Yeah, I was just gonna say that I'm not sure why. I guess I wanted to pose this question: why do we want to segregate folks out of criminal legal settings for substance use treatment when substance use treatment, effective substance use treatment, should be available to all people inside criminal legal settings, and folks who don't need to be there, get them out? So what is the rationale for kind of this bifurcation?
is that a question to me?
I think
Yeah.
so.
Okay. Yeah. Well, look, the state prison system and county jails aren't the best place for treatment. They seem to be a good place to get drugs. Sometimes it's just as easy to get drugs in prison as it is, in West Sac in my district, in Brighton Broderick neighborhood, or wherever, or even upscale neighborhoods. So, like, number one, that's a certainty. I guess number two is, the big picture is, I view that, yeah, I would like to have more out treatment. What's the word again? I screwed it up.
Outpatient.
Outpatient treatment, yeah, where people aren't sentenced to each of these, but these individuals that the judge is going to determine there's a public safety risk, there are not minor crimes or not misdemeanors, that they're going to be sentenced to a term, and I'd rather have them get treatment than not treatment. And right now, there is no good, I think, effective, solid treatment program in our, nearly 100,000 population state prison system and our county jails. And so this, I think, would be an idea to focus on a small subset of people in YOLO. And I think what really intrigues the legislators, I can't speak for 120, but I've talked to many of them, including myself, who's, authored a ton of bills and supported a ton of bills to get rid of our mass incarceration system, is that this is worth a shot, right? This is what a pilot is. I know the opposition says this is 100% guaranteed not to work. Well, maybe they're right. I don't know if that's the case, but that's what a pilot is. That's what a science project is. And what's the worst thing that could come out of this? An individual would either be in prison, getting no treatment, or have probably a shortened sentence in a secured drug treatment facility that, is not prison-like. It's secured, people can't jump out the window and walk away, but it's not going to have bars and guns and so forth, as our DA noted. So I just see in our business, it's risk reward, upside versus downside. And in my view as the author, and so far in the hearings, I think the legislature, who, as you know, is very driven towards criminal justice reform and dramatically changed our sentencing laws in the last 10 years, think that there's much more upside than downside here.
Robert?
Thanks, David. Assemblyman, I want to maybe offer an alternative to what you said, that there's no treatment available in our jails and prisons. One, I work for CDCR, so I'll get there right up on the table. And
I know there is. I'm going to interrupt you, but I'm just saying, I know that there is, but it's not great. It doesn't really work. You can easily get drugs in our facilities.
Okay, so but I would have to argue with you that because you can get drugs doesn't mean that there are a subset of people who wouldn't benefit from, and particularly something called medication-assisted treatment, which is a very effective treatment and is being utilized in CDCR and could be utilized in Yolo County's jail, but it's not. And I think that the notion that somehow we've got to wait until they're sentenced to provide treatment is really working against the principle that we need to, we could be providing, using these funds from the opiate settlement agreement, for instance, to provide medication assisted treatment and other treatments in the jail from the minute they walk in the door. They're going to be arrested for felonies, so they're not going to typically be released on their own recognizance, and they're going to spend time. I think the county estimates that it's somewhere around 35 days or so. There's 35 days of opportunity that we're not taking advantage of right now. And then once they have, let's say they've been in treatment in the jail, they're on medication-assisted treatment, buprenorphine or some of the other treatments, and then they get to the judge, and the judge sees that they've won, they've been in treatment, and so there's an opportunity to give alternative sentences at that point. So rather than putting them in what is called a secured setting, which I honestly, it sounds like jail light to me. And it just, and I will agree with the other panelists that coerced treatment, really the outcomes just are not very good. So that's my piece about this.
Okay, Christina, you wanted to chime in?
Yeah, sorry, I just want to make a couple points, just because I've been taking a few notes and apologize if I miss anything. But I know that folks, one of the questions was, why do we want to segregate them from the criminal justice system? And I guess I just want to highlight that, and I'll speak for my boss if that's okay, but our vision is really just to have a treatment facility that's run by treatment providers and provide that type of setting, more of a clinical setting rather than a jail-like setting. And I guess I have a question too, in terms of, we already know that there is treatment in the jails, but how long does it take for them to access that treatment? And in regards to MAT, I'll remind you guys of a bill that my boss ran a couple times, and it was regarding, charging pharma, taxing them for purposes of MAT. So we've seen the work of MAT, and we definitely want to incorporate it. So I guess that's just a couple questions that I wanted to raise and flag in terms of the vision of the bill and where we're going with.
All right, and Leah?
Christina, I applaud that vision. I think there's probably no one who opposes the idea that folks, with health issues should not be put into, these very harsh, dangerous spaces. I guess rather than theorizing about stuff, I would just point to the experience in Massachusetts that has a lot of these facilities, and we involuntarily commit about 10,000 individuals per year on substance use grounds, and the outcomes are not good. These facilities, even though they're supposed to be, more humanistic and less harsh, end up looking very much like jails. I think Dr. Canning's characterization of them being jail light is correct. They also, to Assemblymember McCarthy's point, there's a lot of overdoses inside these facilities because you can't keep drugs out of places where people really want drugs. If you're not providing effective treatment, as in Massachusetts, until very recently, we were not providing, the demand is there. And so the economic incentives are such that drugs can find their way inside the most secure spaces. So it's not realistic to expect that somehow, these facilities would be quote unquote drug free. And, again, I would just point to the experience around the country where facilities like this have been set up, and the experience is not, unfortunately, not reflective of this more humanistic, more positive vision, which I applaud, and I think everyone else does as well.
So I know, David, we have like 20 minutes left, 15. So maybe we could just kind of rapid fire questions for me. I know that's the big part. This is a forum, but you wanted to make sure you asked me specific questions. So maybe we can focus on that for the last 15 minutes.
Yeah, and there's probably a ton of audience questions. Lynchy, I hope you've been going through them as they come in. So
yeah,
you can throw some of those out that you can address. Kevin, did you want to respond to anything though?
It's kind of overwhelming. It's hard taking notes of so much, but let's spend the last 15 minutes doing one question at a time. We'll go. Okay,
Lynchy, go ahead.
Yeah, so I'll start with one of our very first questions regarding the timing of the treatment. Is the timing of the treatment limited, or how is it set? Or is there a possibility that people would be held treatment for longer than they could have been sentenced under the crime for which they were charged?
No, the intent is that it will be equal to or less. And we think that the treatment options would be less. And again, the sentence to this piece would be laid out there in an option by not the DA, not the judge in consultation with health professionals would be an option, and the individual could choose. And that's what I think is the big picture. This is a choice. You can choose once when you want to do this, or you can choose when you get there, and it's an option to jump out as well. And I see people's comments. I can't read them all, but I have no problems clarifying that the treatment shall be no longer than a sentence. I know someone just said that, the intent, but that'll be in the law.
Thank you. And then the next question we have from Amanda Massimini. She asks, will this option to apply for alternative release no longer be available for people who change their mind during the cooling period? Or will that be left up to the sheriff's discretion?
I don't know how the sheriff's involved with this, and I don't know. I'm not an attorney, so I'm not sure what the alternative release time in a person's sentence. Most of these are short sentences. They're not, we don't have serious violent crimes in here anyway with longer sentences. So I don't know how, somehow you'd be able to get out of your term sooner. I'm not sure. Rod, did you have any? Can you want to opine here?
You're muted, Rod.
Rod,
You're muted, Rod. Yeah, I can't hear you.
How's that? Is that better?
There we go.
Yeah.
Okay. The first comment I want to make in regard to a comment that was made earlier was, I don't know any of my clients that would voluntarily go into a drug treatment program, whether they're in custody or not, if they were not compelled to do that. I can probably count on one hand with fingers left over the number of times someone's come to me from the street not facing a criminal charge and said, can you get my son or can you get me into a residential treatment program? So again, I think the point that needs to be made here is that, yeah, its success rate is probably going to be troubling. But the reason for that is because most people who have addiction are going to relapse several times in their life. They're going to do that whether they're on the street. They're going to do that whether they're going to work every day and they're not in the criminal justice system. They're going to do that regularly. The failure rate is going to be a high failure rate because of the availability of drugs and alcohol on the street. But I support this program not because I think it'll be a raging success, I hope it is, but because it gives my client yet another set of alternatives. And if anybody thinks people are getting drug treatment in jail, they have forgotten about the pandemic, because my clients are not getting drug treatment in jail and they're not even able to see their families by Zoom. So an alternative that is proposed for our county to start is something I'm just fully supportive of. I'm really proud of our county for doing it, and it's a pilot program. I guess we just have to see how it goes.
Thank you, Rod. And then next I'll have a question from Nancy. She asks, if clients fail the treatment and end up getting sentenced, will the time in treatment count towards time? There's also a follow-up question saying, would people get day-for-day credit towards their sentence for the time they did do in the program, even if they ultimately failed the program?
I think I can speak to that. The basic rule in regard to residential treatment programs is that you get credit for the day you're in it, but you do not get good time, work time credits. I take it probably this might be that way, but on the other hand, it's an in-custody program. So our argument certainly would be that the good time, work time credits would count, and that if they failed the program or decided to leave it, they would get their time credits plus good time, work time for the time they spent in treatment.
Yeah, I don't have any more specific than that answer, so.
Right.
Oh yeah, go ahead, David.
Oh, no, go ahead, Lynchy, with the next question.
Okay, yeah. This one's by Eric Gelber. Would providing the option of treatment not make more sense prior to conviction, such as a form of a pretrial diversion?
Yeah, I would love that, but that's not currently the option right now. How I view it, these individuals, they're not going to have probation. They're not going to be not sentenced. These are individuals that will be sentenced for one way or the other for this underlying, felony, and that this would be a choice for them. And that's why it doesn't include misdemeanors. It's not the lower level cases as well.
I see. And then someone asked for a quick summary or clarification of what the opioid settlement is.
Yeah. So this idea is not just for heroin addicts, and there's just as many meth addicts out there or other drug addicts that are committing crimes to frankly feed their addiction. So this wouldn't be specifically for any specific type of addiction. However, the counties are likely to get a major settlement for the opioid epidemic with drug manufacturers. Think of like Purdue Pharma and the Sackler family, those scoundrels like made billions and addicted millions of Americans. And so we're justice and court system holding them accountable, and there's going to be monies going out to counties, and they can do what they deem necessary to advance public health. So an example, 20, 30 years ago, we sued big tobacco, and counties got all kinds of money, and it didn't have to necessarily go back to fight tobacco and smoking. The counties could use that for other things they thought was important to help with health or public health or anything. So it's very broad. So I think that the notion here is the County Board of Supervisors, they'll have the opportunity to vote on whatever they want to do with this money. So this could be an option for them. But I don't know if it's the only option. Certainly, as Kellen alluded to, Medi-Cal is not a viable option with preemption laws about using Medi-Cal for incarcerated individuals. But you know, I know that the DA and the supervisors have talked about other funding sources, including private funding. Because one thing that we're intrigued about here is this, again, is not going to be in Sacramento or LA. This is a pilot project, and so maybe it doesn't work. But you know what's not working now? People getting sentenced to prison and getting crappy treatment when they're in prison. Frankly, they get more access to drugs than they do treatment. So that's the worst case scenario, that it's not going to work. And the whole overdose claims, they're just the same as they would be if the person is sentenced in prison as well. But the upside is potentially we can look at the practices, including I'm very familiar and heard about what's happening in the state of Massachusetts there. We can look at other programs and craft one and fine tune one that potentially could be a successful model in other areas of California.
Thank you. And then I'll ask Tracy Olson's question. She asks, if AB 1542 results in longer lengths of stay in jail for clients, do you still support AB 1542?
It's my bill. So like, I'm going to make sure that individuals would not stay longer in treatment than they would on their underlying sentence.
And then John Raffling asks, don't you think that judges and prosecutors will be offering this locked treatment for a plea deal? And wouldn't judges and prosecutors use the threat of long prison sentences to pressure people to agree to treatment? And doesn't this just add to another incarceration option?
Well, most of these sentences here are not long sentences anyway, because we're dealing with non-strike offenses, non-sexual offenses. So I don't see how there would be super long sentences in the first place. You know, I'm not a person who's in the weeds on the pretrial and the plea pieces here. So that's not my desire for the bill, to have it be part of leading up to it and coercing someone to take a sentence. It's upon sentencing. Once someone is sentenced by a judge, if it's shown that someone has these characteristics and has an addiction, and I know Leo said earlier we shouldn't use abuse. Okay, but if it's an addiction, if someone has an addiction and this person is shown by professionals that their crimes are fed by this addiction, this option would be available for them. So.
Any left?
Thank you. There's only a few left, but
Oh, let's bring Robert in real quick here.
Okay.
Yeah, and someone says, can we just have decriminalization? Yeah, I'm for that. I don't want to.
We already have that.
I don't want that. But these are for people who are committing crimes because of their addiction. You can't go and rob a liquor store and say, we should decriminalize it because I did it because I'm addicted to methamphetamine. I don't want people to be arrested for possession, for use. We shouldn't have. I think we should have full, legalization. I think it would be safer for a number of reasons, like we've done with marijuana. But these are not drug crimes. These are crimes that can be related to drug addiction.
All right, Robert, and then we're gonna go quickly to some closing thoughts by everyone.
Yeah, I'll just close with say I want to thank Assemblyman McCarty for wading into this. This is a thankless area and extremely complex, as you obviously have found out over the last couple months of working with this bill. I would just say thank you for working with us in the county, but also hope that you maybe broaden the bill as with more amendments to make some of these treatment options available prior to sentencing. So that's my piece. Thank you. Thank you very much.
Who else wants to offer some closing thoughts?
I can go. So I want to thank everyone on the panel, and I want to thank Assemblyman McCarty. You know, we work with you a lot on legislation, and we appreciate working with you. And you know, we take no pleasure on being in opposition on this bill. But I would like to take issue with the characterization of this as a pilot. You know, prisons actually started as a place where we thought we would send people to get reformed, and then they would come back and rejoin society. So from the beginning, this has sort of been the experiment, and this is just creating another incarceration option for people. If we're really interested in pilot programs and things that are going to work, we should be investing in the community. We should be thinking about things like safe consumption sites. We should be thinking about safe supply, and we should be thinking about more progressive drug policy instead of just more incarceration options.
Yeah, I'll just respond that you could have both these things. I support all those. Safe injection sites have nothing to do with a guy who was arrested 22 times stealing stuff from Target in an 18-month period to feed his addiction. Like, that has nothing to do with safe injection sites. And so I just think you're conflating the issues. And then it is legally a pilot in that state law. We write state laws constantly, and we have laws. Most laws are permanent. We change the code. So this changes the code for a defined period of time. So the code change would expire in 3 years. So it's a legal pilot.
I understand that technically it qualifies as a pilot. I'm just saying the idea is not new. It's been tried and has failed.
Okay,
Well,
Leo?
walk down K Street Mall, walk down downtown Davis, walk down West Sac. The system that we're talking about is not working. And I think that, I'll speak very blunt, I think that's why you're seeing Democrat lawmakers like me authoring bills, and why you're seeing unanimous support in public safety, because you know, we need to do things differently, and we're gonna have a lot of uncomfortable conversations, and that's okay. You know, we have to get to, as someone just said, the root of a lot of these problems here in society. But you know, this is not a lock 'em up idea like my DA here in Sacramento, Anne Marie Schubert, who wants to lock up everybody. She's terrible. You know, I don't think Jeff Reisig is Chesa Boudin, whatever his name is in San Francisco, but he's a lot more like Chesa than he is Anne Marie Schubert. So like, we're not about more locking it up. I wouldn't sign a bill like that, or author a bill like sign up for a bill like that. So as we close here, I would just ask you to keep engaging with us and to saying, no, that's not helpful. And as you see, there's plenty of momentum and growing. So we did from the get-go hear from, I'm not sure people on this panel right now, express some concerns, and focusing on making sure that this is not misdemeanors but felonies, clarifying what voluntary is, focusing on expungement, clarifying that it's science-based. So, you know, I think we've accepted like 5 or 6 amendments that were frankly all learned from, you know, engaging with people like you. So I tried to take down a lot of the notes. I'm not sure David or Lynchy, how do you say your name again? I screwed it up.
Yeah, that's correct. Lynchy.
Okay, if you could somehow keep these or screenshot them or somehow and give them to us, and we could either, one, give you an answer, but more importantly, think about them. So your question is really a statement. So if you could give me some of that feedback, that'd be very helpful.
Yes.
We will definitely do that. I did want to get, or did Leo leave? Apparently he left. All right, so Rod, your final comment.
I wanted to make the point that I look at this as a place of last resort. We will explore during our representation of our clients every option to them not having to go into any kind of lockdown facility. We'll explore residential treatment programs, outpatient programs, all the way through. There was a point made that during the time when they're facing charges, they don't get treatment. And the reason for that is because they're not guilty of anything. They're innocent until proven guilty. There can be conditions placed on your OR that you seek treatment, but there's no real funding for that. I also want to make the point that when you turn our clients over to the jail system on county jail sentence, relatively bizarre things happen. I had a client that got 15 years in county prison. And what a lot of people don't understand is that the sheriff maintains the authority to release those people at any time he wants. And my client on that 15-year sentence was out 9 months later because I saw him on my arraignment calendar in custody. So this just seems like something that that we can't go wrong on. We try it. I'm cautiously optimistic, and I'm rooting for it every day. Thank you.
All right, and we'll allow the assembly member to get the last word here if he wants it.
No, I think I said it earlier, so I'm committed to this issue, but this is a deliberative legislative process, and we'll keep working. And I just want to have all you know, this is not, this idea I came up with before I even talked to Jeff Reisig. I was thinking about doing this on a statewide level, because I think our system is so flawed that propping up the current pieces just aren't working. We need to incentivize people to more treatment. Some people say it doesn't work, there's a lot of failure. Yeah, people go through this multiple times before there's success. I know people in my own family and life who've been through this. And you know, it's the same reason you say it should be 100% voluntary. Well, I'm not sure if you know people, but I've known people where there's been an intervention where family members and loved ones go to someone's house and, like, what do? They coerce them to do something, and maybe it works, and maybe it doesn't. But it's better than not doing anything in the first place to cajole, entice, whatever, somebody to get treatment, because the results are terrible out there in our communities. We're seeing it, and you know, frankly, some of us are afraid that if we don't step up with creative solutions, we're going to go back to the Anne Marie Schubert rule of the 1994. I mean, she's absolutely terrible in her agenda for California. You know, she's running like it's 94. We're 2021. But does that mean that we can't look for innovative ideas? And I think this is one. It's been wholly embraced by, so far, almost unanimously by Democrats in the legislature. So I'd ask you to see the writing on the wall and don't just rage against the machine, us, and just work with us to come up with a solution that you think is going to be better. And again, we've done that. We've taken a half dozen amendments to, I think, our direct response to some of the feedback we've gotten. So let's keep talking. I have another Zoom to get on, and hopefully I can see all of you in person one day. Thank you.
Thank you. Thank you,
Bye-bye.
everybody, for coming out and participating in the lively discussion tonight, today. Feels like tonight already. And thank you to the audience for coming. This has been a presentation of the Vanguard, our monthly webinar. So thanks